Public Defender Natalie Pate with and on behalf of Ms. Sherry Walker, who is approaching.
Hi.
Please state your name for the record, ma'am.
Sherry Walker.
All right.
Teresa Claire on behalf of probation. Your Honor, Ms. Walker is before the court for a violation of probation hearing. Ms. Walker is in violation of the terms ordered by the court in that she...
Here we go again, probation violations galore. Sherry Walker steps back into court, and the list of what she didn't do is longer than what she actually completed. Missed substance abuse programs, mental health treatment, community service, you name it. She skipped it, and wait for it. For new criminal charges while on probation. That's not just non-compliance, that's a highlight reel of bad decisions.
Owes a balance of $1,218 having made payments. She failed to complete a substance abuse assessment and or treatment. She failed to complete a mental health assessment and or food and treatment. She failed to complete 25 hours of community service, failed to report to probation as directed, and has 4 new pending criminal cases, one being a possession of drug paraphernalia, a retail fraud, second degree, another possession of drug paraphernalia, a retail fraud, first degree, second offense, and a retail fraud, second degree, second offense. All of those incidences happened after being placed on probation. Given Ms. Walker's non-compliance with the probation and her failure to follow through, probation is recommending that Ms. Walker serve 365 days in jail with credit for 13 days served to date to serve the balance that she completed in jail on-farm program with consideration of early release upon completion, waive remaining terms, accept her financial obligations, and discharge her from probation.
Notice how probation's not playing around here. A full year in jail with just 13 days credited. But they're dangling a carrot, complete the in-jail program, and maybe she gets out early. That's the system trying to offer a structured second chance. If she'll take it seriously.
Thank you, Your Honor. I did have the opportunity to meet with Ms. Walker and discuss these violations of probation with her, as well as the jail recommendation. We do acknowledge and admit to the alleged violations, and I would ask to argue against the jail recommendation, however, when appropriate.
All right. You mentioned the violation.
Yes, Your Honor.
All right, go ahead.
So, Your Honor, I was able to have a very long, meaningful conversation with Ms. Walker. And first off, she does want to apologize to the court that she did not.
Now, the public defender makes her pitch. And you can feel the shift. This isn't just about missed checkboxes anymore. It's about context. Ms. Walker lives alone, is a caregiver, and has a possible job lined up. These aren't just excuses there. Real-life consequences of jail time that could spiral her right back into homelessness.
Complete the terms as ordered on probation. And she does acknowledge that she currently has some pending cases, and I do not want to comment on those as they are still pending, outside to point out that it is my understanding they are all non-assaultive allegations. My client does reside in Ypsilanti by herself. She receives Section 8 housing. Ms. Walker states to me that prior to her receiving Section 8 housing a year and a half ago, she was a resident of the Delana Center. Since receiving this housing, her life has changed in a lot of positive ways, including that she has potential work at a laundromat actually down the street here. She is a caregiver for her mother, who resides in Ypsi. Her mother is 83 years old and is unable to really get around. My client is also engaged at the Hope Clinic on Harriet Street and has even spoken to people there about the possibility of potentially volunteering. My client is very concerned that a year in jail, of course, would leave her likely losing her Section 8, as well as then her current apartment that she's been in for a year and a half. She even stated to me she thinks the TV and the lights are still on at home, and she's concerned about paying rent, which Your Honor's aware is on due as usually due on the first. In her case, it certainly is that she has to pay her portion of the Section 8. My client states to me that she came into custody when her name was ran and she was picked up. And she states to me that she does not believe any new charges are coming from that police contact. Ultimately, I'm asking the court to consider discharging Ms. Walker from probation without improvement. Closing out this case and not imposing the jail time so that she can maintain her housing.
Ma'am, is there anything you want to tell me before I impose sentence?
Yes, sir. How you doing?
And here comes the emotional center of the case. Ms. Walker lays it all out. Addiction relapse, broken support systems, and isolation. She paints a vivid picture, blinds opening to a dope house, struggling with temptation, trying to get clean. It's heartbreaking, and it's very human.
Remember, I lived in Montgomery, resided in Montgomery, and we did the Zoom, and you had gave me some community work to do, and I was in the Salvation Army, but the husband and wife got in trouble by using drugs, so they closed it down. But I did do some community work there, some hours there, and also I also was going to my court during the through Zoom. I was doing all that. So like when I opened up my blinds every morning, it was a dope house there and the church that I was doing community work there, service there for you. I was just struggling, you know, because I love to open up my blinds every morning. And so, you know, I was doing so well until one day a friend of mine brought up drugs, and I forgot I even did drugs. I was doing so well. And so I got back up here. I went to the Delano Center. While I'm on drugs, I was determined and got on Section A. And now I live by myself on LaForge. And I'm the only one with the key. And I do believe I left my lights and TV on. And I don't know no neighbors out there because I was only out there a year and a half. I haven't been out there. And then they're like coming through, you know, because we was on the news about the mold and all that kind of stuff. And so Section A have people coming through certain house apartments to check the the mold and the whatever that's what's wrong with our apartments since it's been what you call it, new management, ill property. But I haven't been on if you can release me to I haven't been on Tether over 40 years as I was, you know, in juvenile. I haven't experienced being on Tether as an adult. So if you can please release me, if possible, so I can take care, I don't lose my place in my Section A. And you can put 2 of them on my arm, my wrist, and my ankle. And I would do anything that you want me to do. If you just give me a chance on Tether, I'll pay the fines. I'll drop clean. Because I have a job down the street, the laundromat. I can give you documents of that when I go to work. And also the owner of the laundromat saw my work ethics. And he gave my friend an application to give to me to fill out for as a fill-in. So I have that going for myself, and the whole clinic, I have that going for me. And I just can't do everything. I just can't be locked up and lose everything, be back at, on the streets. And the only thing I love, I will show you. I'll drop clean. If you give me one more chance, release me the topic. I can show you. And then if I mess up there, I swear I'll just do whatever you want me to do. But please, can I go home?
How did you come back into custody?
This moment right here is pivotal. The judge asks, "You knew you hadn't done anything on probation." And Sherry doesn't deny it. She starts, she stumbles, but there's no strong justification. Legally, this is the nail in the coffin. The judge gave her a path end. She admits she walked away from it.
I was on my friend's house, lived across the street from me. She was about to do my hair. And next thing I knew, they just busted the door down. And they ran my name. And that was that. And that's how I ended up here.
Because I originally sentenced you back in January of 2023. You didn't do anything on my sentence. We had you set to come back April 10th of this year on the violation of probation. You didn't show up. And now we have you back.
Can I respond to that? My mail was going to my mother's address. I didn't have a place then, and she didn't tell me that I had court and then like that. And I'm not gonna lie on my mom, but I didn't have a place then. I just recently got my place, and I didn't know because my mail was going to 2302.
You knew you were on probation.
Yes, sir.
You didn't call probation.
No, sir.
You knew that you hadn't done anything.
Well, I had started down in Montgomery.
You knew you hadn't done anything on probation. Right?
Yes, sir. But
You'll hold the keys to whether or not you get out of jail, but I'm going to order the 300.
Boom, the gavel drops 365 days in jail. But listen closely, the judge still leaves a door open. If she finishes the in-jail program, she could walk early. Plus, no more hanging probation terms or financial chains. It's harsh but not cruel. It's the court trying to thread the needle between punishment and rehabilitation.
65 days in jail, credit 13. Defendant is to serve the balance. I will consider release upon her completion of the in-jail non-farm program. I'll waive all other remaining terms, including accepted financial obligations, and discharge her from probation without improvement.
Thank you. What that mean? I gotta do a year.
Hey, can you hear me, Mr. Harris? Can you hear me?
Yeah.
Okay, good enough.
How you doing, Your Honor?
I'm doing well.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Harris. Mr. Harris, could you state your name for the record, please?
Edward Harris.
Mr. Clare, on behalf of probation, Your Honor, Mr. Harris is before the court for violation of probation hearing. Mr. Harris is in violation of the terms ordered by this court in that he owes a balance of $1,095, having made no payment. He failed to report to probation as directed. He failed to provide proof of substance abuse treatment and failed to complete or provide proof of a mental health assessment. Mr. Harris additionally has had new police contact with a new case being filed or submitted to the prosecutor's office. Your Honor, that alleged date of offense was May 3rd, 2025, with the requested charges of larceny in a building. Probation is also aware that Mr. Harris has in violation of probation hearings out of circuit court. That's going to be addressed there. It's my understanding from the felony probation office that he's likely to serve jail time in those matters. Given all of the circumstances, probation is recommending that Mr. Harris serve 365 days in jail with credit for 88 days that he served today, that he served the balance. If he complete the in-jail MRT program, for the court to consider early release upon completion of that, waiving all other terms except his financial obligations and discharging him from probation.
Your Honor, I did have a chance to speak with Mr. Harrison, Ms. Pilara about this. I'm going to ask for an adjournment of this hearing, actually, to see what happens both on the felony case, as well as I would like to get some documentation from Mr. Harris's caretaker, his sister. He's been having pretty significant memory issues. He had an aneurysm earlier this year, and I want to make sure that if that could have an impact on the sentence, the court and probation has that information, and to see if felony probation has that information as well. I mean, frankly, Your Honor, if I ask Mr. Harris if he's been diagnosed with dementia or Alzheimer's, he doesn't remember. So he's been having some memory issues, and like I said, his sister is his full-time caretaker. So I just would like a chance to speak with her more, to know more about what's going on with him.
Well, it would seem to me that both could happen. I mean, the significant penalty in this case is the jail time that I would be imposing. I am certainly, if information is provided after you speak with this, to probation and into the court to reconsider the amount of time, if any, that the defendant would serve. So I'm going to decline the adjournment. I think I'm going to go ahead with the sentencing with that caveat that if you provide that information, I'll take a look at it.
Sure. If anything comes to light, I'll get it to the court.
All right. Okay. Sir, anything you want to tell me before I impose sentence?
No.
All right. Given all of that, I'm going to order 365 days in jail, credit 88 days that he served defendant, and I'll order the defendant to serve the balance. I will indicate also that the defendant is to complete the in-jail MRT program. I will consider an early release upon completion of that program, as well as if other factors are submitted to the court that would dictate an early release. I will waive all other further terms except his financial obligations, discharge him from probation without improvement.
Your Honor, if I may ask one question.
Yeah.
I don't know if when Mr. Harris walks out of this room, he's going to remember to enroll in the MRT. Will the jail, since it's court ordered, will the jail automatically enroll him? Do you know? Or any
I don't
of our
think it's automatic.
officers?
But,
I can get in touch with the jail and see if
why don't we?
they can help me facilitate that.
Okay.
Okay.
Do it that way.
Okay. Thank
All
you.
right.
Thank you.
Thank you. You take care of yourself, sir.
Okay.